a PES law that firmly incentivates agroecology, assuring the correct environmental use of land, and more important, nature's protection, that also leaves place for local regulation. Thank you very much.
Good morning, everyone. My name is Ana from Argentina. I'm very happy to be able to participate at this colloquium. Thank you very much, Nick and Michelle, and all of the organization. In spite of the commitment and great effort that the country have been making over the last years on protecting the environment, I unfortunately come to the conclusion that the main environmental problem is loss of biodiversity caused by several agents. Among the reasons for these situations we can mention habitat loss, invasion of alien species, devastation of natural environment, over-exploitation of resources, pollution, climate change, and increase of ocean acidification. The invasive alien species are animals, plants, or other microorganisms introduced by man in areas which are not their natural habitat, where they establish and spread, provoking a negative impact in the ecosystem and local species. Thus, species represent, in a global level, the second most meaningful cause for extinction. The damage is huge and malicious and usually impossible to reverse. Nowadays, the globalization in trading and the climate change allow us to foretell that the increase of the invasion with some certainty in the near future. For that reason, we address this as a local problem requiring cooperation across international proceedings. In Argentina, we have many examples of this damage, but I'd like to mention about the damage provoking for the Japanese oyster in marine biodiversity in Buenos Aires province. This species has settled in a protected area. Besides the damage of the resources, also is affecting the behavior of other species who travels to the area to reproduce, like whales and dolphins. On the other hand, of the introduction and exploitation of these species results in economical or social benefit. For that reason, we need to be very careful and sensible when taking actions. Therefore, the challenge relies on the prevention, on the introduction, control, and eradication of those alien species. The key legal issue is the absence of commitment from the countries to put all the measures and agreements into practice. Governments and sponsors should increase their funds to finance the programs for the prevention, follow-up, and investigation of alien species. In my opinion, the mechanisms would be a review on the current international conventions, perform new agreements into the face of the latest scientific and technological development, focusing on the damage caused by alien species, adopt regional agreements due to the fact that the local communities usually share the same problems, develop conservation goals, provide the community with information and education about the importance of the conservation of their cultural and natural heritage, regain the natural areas affected by the introduction of these species. In order to achieve this, it's important to provide the countries with the necessary tools to be able to commit. We strongly encourage a severe control and appropriate punishment to reinforce the fulfillment of the agreement. Thank you very much.
We have our next video from Wang Jinping from Wuhan University in China. have to move to the next step, but we'll place these slides online for people who are interested in looking at it.
Hello. Okay, hi everyone. I'm going to talk to you about deep seabed mining. Sorry about that. Deep seabed mining in international areas, in the international area of the deep seabed, which is subject to actually increasing pressure because there's a more and more prospecting and exploration activities going on there because of the growing interest of the mining sector. Now, mining, in particular the exploitation phase, to which we're not yet at, is a very destructive activity per se, as it consists of excavating minerals from the seabed. Moreover, deep sea ecosystems are not only fragile and vulnerable, but also very badly known by scientists. In fact, the scientific community constantly raises flags about the importance of the knowledge gaps in this respect about the vulnerability of ecosystems in the deep sea. So then what are the legal issues related to that? The regime of the international area of the deep seabed under the Law of the Sea Convention is built around the principle of common heritage of mankind, which implies and strengthens the need for sustainable mining and conservation of the environment for future generations. Now, the International Seabed Authority is the responsible organization to implement the Law of the Sea Convention regime on deep sea mining on behalf of mankind and the future generations. Now, the authority has drafted a mining code in the form of regulations. However, the environmental dimension of the mining code is fragmented throughout the diverse regulations, which make any assessment of the legal framework really difficult. But when you manage to do so, you realize that the environmental process through these fragments, in particular the impact assessment process, is discontinued and not really adequate to best environmental practice, partly because of the current lack of regulations for the exploitation phase. So there's only a part of the regime that is currently implemented. Now, some entrenched elements of best environmental practice are lacking too. For instance, there is no public information and participation mechanism at the moment. And the ISA, the Seabed Authority, is an intergovernmental organization with both legislative and executive powers given by the Convention on the Law of the Sea. Now, its current structure and means is probably unlikely to allow the Seabed Authority to fulfill its executive functions. Now, what legal mechanisms and areas of reforms are necessary to address these issues? Well, I have some bullet points about some recommendations. Of course, I cannot address all of it in 5 minutes, but I could say that, for instance, in the current drafting process for exploitation regulations in the mining code, they should be more best environmental practice entrenched in there, such as public participation, the involvement of independent experts with regard to impact assessment. They should be really entrenched in clear procedural requirements. There's currently really a lack of clarity through procedural aspects of the mining code. Publicity should be the rule and confidentiality the exception, and not the other way around as it is now. It is advisable that the environmental matters are treated separately in an environmental code rather than fragmented throughout all the pieces together. And there is currently a performance review going on about the Seabed Authority's structure and functions, and these performance reviews results should allow for a structural reform of the Seabed Authority and also for its internal management systems. Thank you.
Good morning, everyone. My name is Tyra Snips, and I come from Bangor University in North Wales. And I'd like to thank Nick and Michelle for giving me the opportunity to escape a week of horrendous weather there to spend the time with you in Rio. My research actually focuses on 2 areas. One is the environmental consequences of war, and the second is human rights and climate change, which is what I'm going to focus on today by exploring the question of whether we have a human right to geoengineering. The Paris Agreement that was adopted last December was rightly celebrated as being an achievement in terms of international climate diplomacy. It made huge strides forward in the field of climate change regulation and in particular mitigation. But that agreement has also, as you well know, been criticised by many for being potentially too little, too late to save our planet from the doom and gloom ahead. And that, I think, criticism raises very serious questions for us to think about, questions which I think will probably guide all of our research over the coming decades. In the context of the Anthropocene that we're focusing on, I suppose, today, I wonder whether human rights can maybe support environmental law and the environmental movement by providing maybe an alternative approach to devising ways forward. And in that regard, I'm just going to focus on one particular human right today, the right to enjoy the benefits of scientific progress. Now, if you've never heard of that human right, you're not alone, and fear not, I didn't make it up myself on a slow day at the office. It actually was devised and contained in the Universal Declaration of Human Rights back in 1948, and it was given legally binding effect in the Covenant on Economic, Social and Cultural Rights in 1966. But to put that right in context for you, Herschel, the international jurist that we're all probably very familiar with, described economic, social and cultural rights as being at the vanishing point of human rights law. And William Shavis, a genocide scholar, said that the right to enjoy the benefits of scientific progress is at the vanishing point of economic, social and cultural rights. So we're not really talking about the heavyweight champion of the world here in human rights context. But what does it have to do with geoengineering? Well, geoengineering is a very divisive subject. It divides opinion, and there's a lot of negative rhetoric associated with this particular approach to climate change and climate change mitigation. But the human right to enjoy the benefits of scientific progress, particularly its legally binding one in the Covenant on Economic, Social and Cultural Rights, creates an obligation on states to respect the freedom that's indispensable for scientific research. And I don't know if you're aware, but there's a kind of a suppression of research into geoengineering, or at least a discussion of approaches to geoengineering. And it's my view that geoengineering isn't a panacea. It's not the solution. And it has to be coupled with traditional climate change mitigation to work. But by suppressing research into geoengineering, states that are party to the Covenant on Economic, Social and Cultural Rights, and they are many, may be violating our human rights to discover what geoengineering options may be available to us in the long run. So I would put it to you that perhaps a human rights approach to the question of geoengineering may be a way to cut through that negative rhetoric, but it also may be a way to secure the success of the Paris Agreement in the long run. Thank you.
Good morning everyone, my name is Adélia, I'm from Brazil, I'm a lawyer, and I have a master's degree in social environmental law. So, Jill and I wrote about the treatment of climate change in our country, and the title of our study is the National Climate Change Policy, Analysis of Measures Adopted by Brazil to Fight Global Warming. We know that in the last 2 centuries, man have caused serious environmental impacts on the planet because of economic development, as climate change due to global warming. Because the temperature of Earth is rising, international community needs to develop tools to mitigate climate change. From this point of view, the United Nations Framework Convention on Climate Change, as you know, it was established in 1992, set goals to reduce greenhouse gases concentrations in the atmosphere. Let's remember that the Kyoto Protocol was signed during the 3rd Conference of Parties to the COP3 in 1997, aiming the reduction of 5% of GHG emissions from industrialized countries. Since then, many GHG reduction targets have been discussed in the Conference of Parties all over the world. For this research, the 15th Conference of Parties to the COP15 deserves attention. Despite this conference ended without progress and the leaders couldn't establish greenhouse gas reduction targets, Brazil presented a national policy on climate change which aims the development of a governance program for issues related to climate change. The policy brings a national voluntary commitment to implement actions in order to mitigate GHG emissions, reducing its projected emissions until 2020. The national policy on climate change has instruments to reduce GHG emissions, such as the National Plan on Climate Change and the Action Plan for Prevention and Control of Deforestation. The National Plan on Climate Change seeks GHG emission reduction through several targets, such as, first, the reduction of Amazon deforestation rates by 8% until 2020. Second, the expansion of domestic ethanol consumption by 11% per year over the next 10 years. Third, to double the forest area planted to 11 million hectares until 2020. And finally, we increase recycling of municipal solid waste by 20% until 2015. We have two action plans to prevent and control deforestation. One, the legal Amazon, which is related not only to land and territorial planning, but also the monitoring and control of sustainable productive activities in the region, and the other one in the region called Cerrado. It must be noted that several measures surround these plans haven't been implemented yet. So, we can conclude that the efficiency of GHG mitigation plans approved under the National Policy on Climate Change haven't been questioned, since there isn't any procedure to provide transparent reporting on their implementation, jeopardize Brazil's targets for 2020. So that's it. Thank you for your attention.
Hello, good morning, everyone. Bom dia a todos. My name is Priscilla. I have a PhD in international law from Paris I University, and currently I'm teaching transnational environmental law at the Brasilia University Center. My submission entitled The Adoption of Sustainability Clauses in International Sales Contracts as an Innovative Attempt to Materialize Social Corporate Responsibility does not deal with a specific environmental problem, but deals with general environmental and social problems that may arise in international supply chains. So companies, especially multinationals, are increasingly confronted with the need to ensure that their business partners are not engaged in unethical practices. So in order to avoid these unethical practices, and in order to avoid threat to their reputational damages to the companies, companies are starting to integrate public goals into their private relations. However, implementing corporate social responsibility throughout the international supply chain poses special challenges, since companies involved, even if they are dependent economically, they are legal independent entities. So that is one difficulty. And the other challenge is to identify the ideal mechanisms to enable companies to pursue public goals as well as means to legally enforce them. So the second question is what is the key legal issue? The key legal issue is that this topic relates to the fact that the promotion of sustainability can no longer depend on states alone. So the applicability of national law is geographically limited, and international public law, for instance, only regulates companies' cross-border activities in some few cases, but normally it applies indirectly and depends on state legislation. And states are not able, or sometimes are not willing, to meet their international obligations in terms of environmental protection. That is why other actors and private actors are increasingly being considered. So considering the third question that was posed, looking into the future, what are the legal mechanisms and or areas of reform necessary to address these issues? And what will be considered in addition to legal frameworks? So companies can choose many sorts of instruments such as certification, reporting, and other code of conducts, for example. But taking into account that international trade in goods occur through contractual arrangements, it is possible to consider that private contracts can also be considered as a legal mechanism to promote sustainable development. Contracts may regulate environmental and social impacts associated with manufacture of products, and depending on the way these contractual clauses are drafted, contracts may give soft law and self-regulatory CSR instruments a hard law perspective. So actually the idea is that what was supposed to be just a voluntary CSR commitment becomes a contractual obligation. And this is the point that deserves further legal research. The influence of sustainable development in contract law has already been subject of some studies. Many different areas such as climate change and biodiversity have already demonstrated that the use of contracts can contribute to the regulation of some specific environmental concerns. For instance, in my specific research related to the international trade in biofuels, it was possible to identify many different types of contractual practices involving the integration of sustainability clauses. For instance, Shell, a very known enterprise, has integrated sustainability clauses in all its chains. So my time is ending. What are the areas of reform in contract law and that need to be considered? I would mainly state three. Drafting, enforcement, and right of third parties are the main issues that need to be considered. Obligations identified in sustainability clauses varies a lot, so maybe a harmonization of these clauses needs to be considered. Judicial enforcement of these contractual arrangements needs to be further considered also. Questions related to understanding why there isn't case law on these issues, for example, needs to be analyzed, since companies simply do not take disputes over sustainability development clauses. And thirdly, the rights of third parties, so we need to reconsider basically the principle of privacy in contract. Thank you.
I would like to meet all of you in person at the Visa Global Colloquium of Early Career Environmental Law Experts. However, my funding can be kept to social activities. I was asked to answer just of all of you 3 questions, and here are the answers. The first question was, what is the main environmental problem or challenge? My research interests are very much in the area of the intersection of energy and environmental law, mostly on a European level, but however, I think the challenges are usually the same on it. So I think from my research angle, a very important problem or challenge is how to balance energy supply security on the one hand and environmental protection on the other. I guess this is very important, even if with the Paris Agreement states agreed to move towards renewable and just more sustainable energy. However, even if we are on the way away from fossil fuels, also renewable energy are considered environmental problems. You all know that wind power can have very negative impact on onshore land use and offshore in regards to mounts and other animals. And biomass is very much a challenge of food security problems. And there's, at least in the European Union, lots of opposition to also renewable energy. So I think the challenge is how to balance all this policy and legal context. It is the problem is how to balance the right approach and what is the best approach. How much wants the state intervene? How much do we leave it up to the market? And how much are private actors in the duty of acting? This was the reply to the first question. The second question is, what is the key legal issue? I guess from my research area, the key legal issue how to promote the renewable energy, more clean forms of energy, and by legally. This is most others feed in tariffs, how are they best designed, state aid and other subsidies, how can they be allocated to different forms of renewable energy, and can be made very effective to also promote environmental protection. Another key legal challenge is how to engage the civil society in decision making, and how do the individual promote from renewable energy projects so that they are more in favor of these projects. I guess more concretely, are there alternatives available to renewable energy projects and where are there? And how is the civil society involved in the environmental impact assessment procedure? In short, it's bringing the IUCN principles to life. The third question you asked me to answer is, looking into the future, what are the legal mechanisms and or areas of reform necessary to address these issues, and what will need to be considered in addition to legal frameworks? I guess I already hinted at it in answering the previous question. An area of reform, and in my opinion, the environmental impact assessments and how the decision-making procedures are included in the different jurisdictions, and also how are transparent environmental impacts addressed and how is the procedure so that all stakeholders are integrated and that can input into the decision making. The implementation of the Argus principle in all the jurisdictions, and especially as that local communities are involved. And I think in addition, we also need more economic incentives for renewable energy, environmental protection for individuals, and how, or we need to create more mechanisms to promote these, such as decentralized energy systems. This is from my part. I hope you agree with some of these points. If you don't, it's all okay. I would very much like to get into discussions and see you later at the hall. Thank you very much.
Good morning, everyone, as it is in Brazil. My name is Remy Kinner. I'm an honorary research associate with the Institute for Marine and Environmental Law at the Faculty of Law with the University of Cape Town in South Africa. And the topic of my presentation is the future role of international water law in transboundary freshwater governance, and how can global water conventions support the existing and future basin agreements to resolve water conflicts. So moving on to slide 2 of my presentation. So what is the main environmental problem and challenge? Well, worldwide there are 263 transboundary river basins that cover approximately half the Earth's surface. And those basins contain roughly 40% of the population and a supply over 60% of the freshwater used worldwide each year. Saying that, there are frequent and intense competition between states and other actors for those limited resources of freshwater. There are 145 nations which have part of their territory within an international basin, and 21 countries are situated entirely within an international basin. On to slide 3. There are significant threats, as we know, to freshwater quality and quantity around the world. And 3 key areas are: there are more frequent pollution incidents from industrial and agricultural point and non-point sources. One example being the Samarco mine spill in Brazil last year, and the diffuse pesticide, fertiliser and livestock runoff polluting rivers, as is the case across the world, but frequent examples are cited recently regarding agricultural contamination in China and US rivers. There's also escalating scarcity due to more dramatic seasonal and precipitation variability, plus rising temperatures from climate change, leading to chronic droughts as we're seeing around the world, one notably within southern Africa, but also here where I'm based in the Mekong River Basin. There's also proliferating large-scale infrastructure projects around freshwater sources that are altering water flows, sedimentation loads and aquatic species breeding environments. So, and another example of that is hydropower dams along the Mekong River mainstream and the tributaries. Moving on to slide 4. So what is the key legal issue? So in the lead up to the Conference of the Parties 21 in December last year for the UNFCCC, much of the talk was around a treaty shaping future access to and benefit sharing of global freshwater resources. Some people went to the extent of arguing that any agreements would actually ultimately determine the fate of shared waters globally, and that this would make or break the prospect of burgeoning water wars, so to speak, as they've been coined, the phrase, involving many of the world's transboundary river basins and transboundary lakes. Given the geopolitical and socio-economic importance placed on these increasingly scarce and increasingly degraded freshwater resources that are shared between states and other stakeholders, it's no wonder then that the popular notion of water wars is rising. On to slide 5. So what are the legal mechanisms and or areas of reform? Well, the water wars discourse overlooks the continuing role of international water law, specifically regional, basin and sub-basin agreements, in bringing states and other stakeholders together to cooperate in order to prevent, ameliorate and ultimately resolve any potential conflicts over water. And what we have is history shows us that conflicts over freshwater are not a new phenomenon by any stretch, and the last war specifically over water was fought way back in 2500 BC. The past has ultimately demonstrated that shared water is more so a catalyst for cooperation than a source of conflict. And this is mainly due to the role of international water agreements over these shared freshwater resources, which leads me to the fact that for the first time in history, we now have 2 global water conventions in force. Moving on to slide 6. So what are the legal mechanisms or areas for reform that I'm specifically talking about? So there are 2 global conventions governing the use of shared waters. One is the UN Watercourses Convention. This was adopted in 1997 by the UN General Assembly, and it entered into force in 2014 when Vietnam was the 35th party to the convention in August. And so it entered into force in August last year, in 2014, sorry. So it's a global baseline framework developed and negotiated over the course of 40 years. So there was a lot of negotiations that went into developing this convention, and it codifies principles and procedures that were already developing and recognised under customary international law. And it's also a convention that's referred to by international courts and tribunals in state disputes over shared water resources, such as the Hungarian dams case, and also in the pulp mills on the River Uruguay case, which was referred to.
Well, I'm sorry to cut off the rest of that, but we'll keep going with the next one, and we'll post the rest of these online as well.
name is Stephen Minnis, and it is a pleasure to be participating in this global colloquium of early career environmental law experts. I'd like to acknowledge the organisers of this terrific event. Our theme today, the legal tools for sustainable futures in the Anthropocene, is very relevant to what I've described as the ocean's climate nexus. And by that I mean the linkages between the climate system, particularly climate change, and the condition of our oceans. These linkages are known to include the link between greenhouse gas emissions and the process of ocean acidification, the ways in which marine biodiversity depletion reduces climate change resilience, but also the function of the oceans as an important carbon sink. Arising out of these acknowledged physical linkages is an important legal issue, which is how do we design legal mechanisms and instruments that jointly respond to both the challenge of climate change and the challenge of protecting our oceans. It goes without saying that there are unintended legal consequences leading from one domain to the other. And we see sea level rise caused by climate change, potentially impacting on the baselines from which the zones are calculated under the United Nations Convention on the Law of the Sea. The challenge